Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a crazy story out of Alabama. A woman's home was demolished by accident. She wasn't there when it happened, but when she found out about it, she went and looked, and sure enough, there's a lot covered with rubble where the home used to be. And strangely, she contacted law enforcement because she figured out who did it. And the cops say, well, there's nothing we can do about it because we don't think they did it maliciously, so you have to sue them. Now, here's the thing. Suing them is actually a viable route, and there's a good way she can do that, most likely. But it is a little scary that a construction company can come out and accidentally knock your house down and not be charged with a crime, because charging them with a crime is the kind of thing that would deter this kind of activity. That is, if a construction company knew that someone could go to jail if they knock down the wrong house, they might make sure they have the address correct, right? So here we go. Woman plans to sue after a construction company mistakenly demolishes her house. This is written by Bill Reales from fox2now.com, and it was sent to me by Vinny, Derek, Dwayne, Michael, and Jeff. Jennifer Pulliam now knows who demolished her house in Alabama earlier this year. But while the mystery is solved, the legal battle is just beginning. Back in January, someone came onto her property next to the Mobile Fairgrounds and tore down a home that had been in her family since the 1960s. She says, I moved here when I was approximately 10 years old. This is my grandparents' old home place. They bought it in 1965. It's been in our family ever since. Pulliam, who lives and works in Leakesville, Mississippi, got word about the demolition through a family member. They didn't know that I was unaware of it until they saw the news story, and then they contacted me, and I cried for 2 days. I was devastated. Now, obviously, she did not live there on a daily basis, but she owned the home, and it was a home that presumably was not in need of demolition. Other family members saw the story, which aired on WKRG, and contacted Pulliam with the name of a company seen on the property that weekend in January. Pulliam then called the police, and a Mobile police investigator contacted the construction company, and the owner admitted to demolishing the house but said it was a mistake. Oops. I was not happy because they said they could not arrest them because there was no malicious intent. She was told I would just have to sue them in civil court. Pulliam, who had not publicly named the company and the advice of her attorney, said she is planning to file a lawsuit. She also claimed that the company's owners have not contacted her to even offer an apology or anything else. And that's the kind of thing where you say, Steve, would you as an attorney tell her not to give the name of the company? Well, it's not that there's anything wrong with that, but the question is, what would it benefit anybody? I know some people are saying, Steve, we should know the name of the company so we can harass them or something. Well, if you're suing them, trust me, that's the only harassment that this woman actually needs to be on board with. But I'm assuming it wouldn't be that difficult for people to figure this out. However, again, it's not like if she were to name the company, they could sue her. No, that would not be the case. As for what kind of damages she hopes to recover, she didn't immediately have a number in mind. I'm not sure what they'll come up with or how they'll come up with it. That house to me is priceless. And so you might say, Steve, someone walks into your office and says, I had a house. It was knocked down by a demolition company accidentally. Can you do anything about it? Now, in Michigan, I can tell you immediately what I do about it, and that's a law called MCL 600.2919A, 2919A. And it's a law involving theft, concealment, and conversion. And it's in the blue books behind me. State law. So I don't know if Alabama has this exact law. A lot of states do. But there is a law on the books that said if somebody steals from you or conceals or converts your property against your rights, contrary to your rights of ownership, you can sue them for your actual damages, which can be trebled, that is multiplied by 3, plus get your attorney fees and court costs paid. And your damages here are clearly either the cost to rebuild the house or the value of the house, or there's a bunch of different ways that you could look at that. Because the question is she going to rebuild? Or, could she scrape the lot and sell it and then sue for whatever else? There's a bunch of different ways to look at it. But also, what was inside the house? Was there anything inside the house of value? Furniture, appliances, things of that nature. And so you sue for those values, and obviously it was knocked down on purpose. It wasn't an accident in the sense that like a big semi truck ran through a T-stop and ran over the house. It was an intentional act that took the house down. And the fact that they took it down accidentally might protect them from a criminal action. It will not protect them from a civil action. And so when they talk about someone doing this intentionally, it's merely somebody walked up to this house and said, yes, I'm going to level this house, and they leveled the house. That was an intentional act. Boom! Treble damages under 600.2919A, along with attorney fees and court costs. So obviously the number one concern I have with a case like this is whether or not that company's collectible. Now, if they're a demolition company and they're going around demolishing homes, and that's what they do professionally, I would assume they have some form of insurance, but I've made assumptions before in my life that weren't correct. Imagine that. Imagine that. And so you'll hear about companies, that say they're bonded and insured, for instance. And it turns out they're not bonded, nor are they insured. So you hope this company either has the assets to pay for this or insurance to cover it. And so when the owner of the company won't talk to this woman, you hope it's because their insurance company said, don't talk to her, we'll take care of it. But if he ain't talking because he realizes I've got no insurance and my company's about to go bust, well, that's the problem. And that would be my concern. And I taught law school for 10 years and I taught consumer protection. And I would often put a question on an exam where the correct answer was, a lawsuit would probably be futile here because you couldn't collect. So I'd give a fact pattern where I'd say this happens, and I would describe what happens and who did it, and I'd give a bunch of things you should do if you were the attorney. And one of them was advise your client that pursuing this as a legal matter is probably fruitless because that defendant is probably uncollectible. And the fact pattern spelled that out clearly. So it was obvious. And I had a lot of students who'd pick one where they'd file the lawsuit anyway. And I remember speaking to students after the fact and also talking about it in classes later before an exam. And I'd have students say, but you're going to tell me you do nothing? And I'd say, if you know for a fact that you're going to spin your wheels and go nowhere, and you know that for a fact, because you can do that in a fact pattern, okay? If you know for a fact you're getting zero, why would you file the lawsuit? And they go, well, you got to do something. Not always. You don't always have to do something. In movies, yes. In an operating room, in the ER, yes. You got to do something, okay? When someone comes into your office with a hopeless lawsuit, you have to say, sorry, it's not worth pursuing. I wish we could. And I've had people say, but let's sue them anyway. I've had people come to my office with cases I knew were hopeless. And I'd say, so we sue them and you collect nothing. Yeah, but we'd prove a point. Yeah, we'd prove a point. It'd spend a lot of my time and your time chasing this. I realize you might not value your time, but I do value mine. And if I know for a fact that it's hopeless, then you don't pursue it. But here, I hope that this company has insurance, and I hope that she gets her money, and I hope she gets more than just the mere value of the house. Because like I said, in Michigan, you can get treble damages. And I've actually had people who've never heard the word treble before. So just make sure you understand this, that you refer to damages by themselves. One would be single damages, but you never use that phrase because it's just damages. If you were to double the damages, you'd have double damages. That's 2 by, right? 2 times damages is double damages. And 3 by, or 3 times damages, treble damages, not triple damages. I've had people say, Steve, you mispronounced triple with a B. That would be tribble, which is something off of Star Trek. Completely different, okay? So treble, T-R-E-B-L-E, means 3 times the damages, or your damages are tripled. I suspect that's an old English thing, but let's not go there right now. So right now, there's no criminal case against the people who knocked her house down, but she's going to sue them, and she's got a great case, assuming they're collectible or have insurance. So it's from fox2now.com. Vinny, Derek, Dwayne, Michael, Jeff all sent it. Thanks a lot, guys. Bill Realis wrote it for Nexstar Media Wire. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
How much deeper would the ocean be without sponges?